Hello, my name is Michael Manna, and I am an elder law attorney. My office is in Ridgewood, New Jersey. I want to take a few minutes today to talk about living trusts. In order to become eligible for Medicaid, and many people want to become eligible for Medicaid because nursing homes right now run between $12,000 and $15,000 a month. I have one client, his wife is on a respirator, he's paying $30,000 a month. You can go broke very quickly. If you become eligible for Medicaid, Medicaid will pay for up to 50 hours of in-home care. It'll pay for adult daycare. It'll pay for assisted living. It'll pay for nursing home. It'll pay for medications. It'll pay for doctors. It'll pay for the rest of your life. But in order to be eligible, you have to be poor. So the process is called planned impoverishment. We want to make you poor. One of the ways to make you poor is to give your assets away. Now, when we say give them away, everybody wants to give them to their children. And I want to tell you that is not the best thing to do. I don't care how good your children are. I don't care how much you trust your children. You don't want to give it to your children for several reasons. Number one, your child could die before you, and now you lose control of that money completely. It may wind up in the hands of your son-in-law, your daughter-in-law, a friend of theirs, who knows? You don't want that. You don't want to take that chance. Your child may get divorced. Your child may get sued. Your child may go bankrupt. Your child may get sick, and then have to use the money for themselves. You don't want that to happen. So instead, you want to give your assets to an irrevocable living trust or a series of irrevocable living trusts. Why? Number one, trusts don't die. Trusts don't get sick, trusts don't get divorced, trusts don't get sued. And you can name the trustee who's going to run the trust, which could be that trusted child of yours. But you could also say if that child dies, who would be the next alternate, and so forth. Okay? Your trust will also provide that when you're gone, whatever's left in the trust goes equally to your children. If one died, his share goes to his kids. If he doesn't have any children, goes to your other children. You can do whatever you want with the trust, and you can specify what happens with the assets in this trust when your child dies. So, number one, it's a much, much safer place to put your assets, okay? I want to tell you, when giving away assets and when dealing with trusts and when trying to get eligible for Medicaid, we are dealing with two federal agencies. One is Medicaid and the other one is the IRS, okay? Now, the trust that we prepare for you, as long as you put these assets in this trust for at least 5 years, they are then safe. You do not have to spend them on your health care after 5 years of putting them in this trust. On the other hand, though, we also have to deal with income tax issues, capital gains issues. And we can use different flavors of trusts so that we can get the best IRS outcome on what we do. I'll give you an example. Your house, let's say you bought your house for $100,000. It's now worth $600,000. You've lived in it, you and your spouse, for 10 years. You sell that house, you do not have to pay capital gains on the first $500,000. You sold for $600,000, your cost was $100,000, you have a $500,000 capital gain. You don't have to pay capital gains on the first $500,000. You could thank Newt Gingrich for that, okay? On the other hand, if you give your house to your children, they sell the house, it's not their principal residence. You have to have owned that house and lived in it for at least 2 of the last 5 years as your principal residence. The kids didn't do that. So they have to pay the capital gains tax on that $500,000 of capital gain. And right now, capital gains rates are 15%. But if your income is over $400,000, it's 20%. And you have New Jersey gross income tax, which is around 8 to 10% on top of the federal capital gains tax. So you could wind up paying 20, 25% in taxes when you sold that house. So you could wind up, if the children got it, they could wind up paying $100,000 to $125,000 in capital gains taxes. But you don't want the parents to own it because you're afraid they're going to go into nursing home. So you set up a certain kind of an irrevocable living trust. It's called an intentionally defective grantor trust. An intentionally defective grantor trust. There are certain provisions in this trust that the IRS says if you have these provisions, we are going to tax this trust like you still own it, which is exactly what we want. So when we sell that house, if the trust sells that house, it still gets the $500,000 capital gains exclusion, just like it would have gotten if you guys still own that house. Okay. In addition, if you don't sell the house and you pass away, the house gets what is called a step up in cost basis. So mom buys this house. Mom and dad, they buy it for $100,000, goes up to $600,000. They don't sell it. Mom and dad both die. They don't have any trusts. But the house is worth $600,000 on their death. The kids then get the house. The kids' cost is $600,000. They turn around, they sell it for $600,000, no capital gains. If they put it in this defective grantor trust, this intentionally defective grantor trust, the very same principle applies, and that is that if they sell it during their lifetime, they still get the $500,000 capital gains exclusion if they would have gotten it otherwise. And if they don't sell it, they both pass away, you get that 100% step up in cost basis. None of those things would happen if you gave it to the children, because they don't own it. They don't get a step up in cost basis. So it's very, very important that you use these trusts. You can also use these trusts for stocks that have gone up in value. And if you put it into an intentionally defective grantor trust, as long as you don't sell those stocks till mom or dad or both of them are dead, no capital gains, because you get this step up in cost basis. So there are various flavors of trusts. I don't really have the time to go through all the aspects of it, but I just wanted you to be alerted to this, because people think, oh, it's going to be easy, it's going to be quick, I'm just going to give it to the kids, it's going to be cheap. Cheap, easy, quick may not be the way to go. And I want to invite you, if you want to come into the office, you can have a free consultation. It's our office policy that the first visit is on the house. Of course, now with COVID, you can't come in, but we can have a phone conference, or we can go on Zoom. And I'll be happy to give you half an hour, an hour. I have the kids on the line, and we can discuss these situations. I can tell you that we charge flat fees for everything that we do. We give you a written agreement, exactly how much it's going to cost. There's no casework. There's no surprises. You know exactly what it's going to cost. There's no guesswork on your part. So I encourage you to do this. And I want to thank you, for taking time to listen to me. And I hope to see you soon. And please stay healthy.